Welcome everyone to Back to Business, Proof of Vaccination and Weekly COVID-19 Testing, OSHA's Impending Emergency Temporary Standard. And we're going to cover updates, legal challenges, and ongoing employer preparation. We appreciate your attendance and we anticipate this briefing to last approximately 45 minutes. My name is Mala Mason. I'm Leech Tishman's Director of Marketing and Business Development. I want to thank you all for joining us for this briefing today. I'm joined today by our two presenters, Phil Toomey and Leah. Phil is a partner at the firm and chairs the firm's National Employment and Labor Practice Group. He also leads the Public Sector Employment Group. Phil is based in our LAX office. Leah is an associate in our Employment and Labor Group and is based in our Pittsburgh office. As you can imagine, both of them have been fielding a number of inquiries from our employer clients since the standard was announced on September 9th. Today, Phil and Leah will discuss the current situation with the developing emergency temporary standard, including updates, legal challenges, case studies, and how employees can prepare ahead of the final announcement of the ETS. There will be a Q&A at the end of the briefing, so please submit any general questions using the chat function, which should be at the bottom of your screen. Alternatively, you can email your questions to info@leechtishman.com. This briefing is being recorded. This briefing is for informational purposes only and is not intended as legal advice. Thank you all for joining us today. And with that, let's get started.
Thanks, Mala. So briefly, we want to review what the ETS is and what the OSHA standards are, which we covered in our previous briefing, which is available on leechtishman.com or by contacting Mala or Jenna. So on September 9th, 2021, President Biden announced that OSHA, which is under the Department of Labor, is going to develop an emergency temporary standard, which is ETS, that will require all employers with 100 or more employees to ensure their workforce is fully vaccinated or require any workers who remain unvaccinated to produce a negative test result on at least a weekly basis before coming to work. And there's a couple of key items in there. One is the edict that employers will be required to ensure their workforce is fully vaccinated, and also that it will be at least weekly testing. So this created a lot of interest, obviously, from employers, especially those who have 100 or more employees, and wondering, am I subject to this? Are my workers going to be subject to these requirements? So OSHA can create these emergency temporary standards, and Phil's going to talk a little bit more about when they can create them and when they can enforce them. But to understand who is subject to them, we have to understand who is subject to OSHA, and that is all private employers in the United States. Here, the specific OSHA ETS has been focused on those employers who have 100 or more employees, and we'll talk a little bit more about why that's significant. OSHA does not have control over federal, state, or local government employees. However, there are 21 states in Puerto Rico who have these health and safety agency equivalencies, and they get to create their own rules for employers that are similar to OSHA standards. And so long as they adopt standards that are similar to or more protective than OSHA, they're not subject to these ETSs. However, we'll talk a little bit later about what happens whenever a state that is allowed to create their own standard fails to do so. And one of the things that is also significant about these states who get to create their own health and safety guidelines is that oftentimes it subjects other employers who are not subject to OSHA to those standards because that health and safety organization for the state has other bodies underneath its control, for instance, local governments. So using this as a baseline that it includes all private employers in the United States as the areas that are under OSHA's purview, what can we expect from this OSHA ETS? What do we think the rules will be that will be included in this particular emergency temporary standard, because the rules haven't been released yet. And without having any type of framework to look at, we look to what has been released. And some of the things that have been released is OSHA did release a ETS back in June of 2021 but it was only subject to certain healthcare employers. And so we can look to that as a framework for what might be included in this ETS, or at least how it may be set up. And then we can also look to the executive orders that have been provided. And those were for executive employees and then also for federal contractors. And while that is not a part of OSHA, they were released and they were implemented as a part of this same Biden administration plan to encourage vaccination. We also can look to communications from the business groups and labor organizations who have met with the White House regarding the OSHA ATS. So with an emergency temporary standard under OSHA, there is no notice and comment period like you normally have with most regulations that come out from the Department of Labor. But what they did essentially in lieu of that is they had these meetings within the past week with various industry organizations. And what we've heard is that it was essentially a listen period. OSHA didn't really provide any feedback. They just listened to the community members. So what we've learned from the original OSHA ETS for healthcare workers in June 2021, and then the executive orders for executive branch employees and federal contractors, is that the definitions in there are very broad and there are few exceptions, and that they focus on vaccination or strong mitigations if the vaccination is not happening within the workplace, as is the case with the healthcare worker ETS. The federal contractor provisions in the executive order in particular focus on what is the contact with the workplace, as well as workers who have contact with the workplace, which limits any hopes that some employers had that remote workers would be accepted. So what the executive order says regarding for federal contractors says about remote workers is that the only exception is if the employer can show with some level of certainty that a remote worker will never have any contact with the workplace or with workers who are going to be in the workplace. And that's a pretty high standard. So you would have to be fairly certain that that person who is working outside of the office is never going to come in to get supplies, is never going to be going to a conference with someone else who works in the office or on site. And those are the only people who were not required to have some of the contacts and some of the provisions within the executive order. And that was only for parts of them. Then for others who were working directly on the projects, they still had to be vaccinated or have to be vaccinated underneath that executive order. So it was very broad definitions with very limited exceptions. And while there hasn't been a case that has been heard yet on that executive order, there have been several cases heard on private employers and vaccine mandates, or employers who have had to enforce vaccine mandates due to local or government requirements. There was a case in Texas regarding a hospital who had mandated vaccinations for all of its healthcare workers. There was a college in Indiana who had required vaccinations for all of its students and staff. And in each of those cases, the courts ruled in the favor of the vaccine mandate. The Supreme Court of the United States has now twice denied to review cases regarding vaccine mandates. And the sports leagues, while not courts of law, but very indicative of the way of industries, have all upheld vaccine mandates where employers have been required to implement them. And so those are some of the places that we have looked in order to deduce information as to what we can expect to be in the final rule for this ETS that will be required of all private employers with more than 100 employees. And so Phil is going to talk about some of the standards that OSHA has to have in order to introduce an ETS.
Thanks, Leah. There's a couple of, I just want to add before I get into my slides, there's going to be just a couple of add-ons. I think as we watch the cases, one of the things that when we talk about the Supreme Court not reviewing, what they have not reviewed are denials of injunctions prohibiting the in current enforcement of the law. So in other words, people have filed lawsuits saying, businesses or entities have filed lawsuits saying, we want to enjoin or stop the mandatory enforcement of these vaccine mandates by and large. And the Supreme Court has refused to enter into the fray of the temporary injunction. They have not yet indicated that they will not review the entire process later, especially as more information becomes available. So we're still expecting the Supreme Court ultimately to weigh in. It's just that the Supreme Court seems to be reluctant to get in the middle of the battle right now. And they certainly seem to be reluctant to prevent mandates from being enforced. And we're just going to have to see how far that goes. I just want to talk a little bit about the interaction of this, whatever this emergency rule is going to be, with OSHA's requirements to protect against immediate workplace hazards. An ETS can be issued and can only be issued, I think I would put that in there, can only be issued when workers are exposed to a grave danger from exposure of substances determined to be physically harmful in the workplace. The rule is urgently needed to protect them, and that the ETS that is actually entered will reduce that risk of injury. So there's three things that an ETS has to meet. There has to be a grave danger. There has to be an urgency that this needs to be done now, and that it will effectively reduce that risk. To survive a challenge, OSHA is going to have to establish that COVID-19 represents a grave danger to workers. And one of the issues that has been discussed in the information we have received during this entire process, one of the tension points in here is this whole 100 workers or more limit. OSHA has never implemented a standard based upon the number of employees. OSHA's standards have always been whether or not there's a hazard in the workplace, whether you have 1 employee or 100,000 employees. It's always been, is there a hazard in the workplace? This is the very first time we are dealing with kind of this magic number. So one of the legal challenges that is already been teed up for this is that the 100-person limit that is irrespective of the work that's being done, the industry, the lack of exposure, the county rate of transmissions. It's based solely on the factor of the number of employees, and there's no relationship between the number of employees and the potential exposure to a grave danger. I don't think that there's going to be a successful argument that COVID-19 is not a grave danger. I think that the issue is going to be is whether or not it's a grave danger in the workplace, and whether or not this 100 or more employees is the magic potion, so to speak, to get the ETS over the goal line. And I do think that that's going to be a challenge, because if you have 100 or more employees basically in a remote workforce, basically not having much, if any, contact with one another, or in a, say, a more traditional office environment versus a closed manufacturing facility, or maybe like a chicken processing or a meat processing facility, those are there are worlds of difference between those two environments. And to try to make it solely on the 100 employee, I think is going to be a significant challenge. the information I have is that has been one of the pushbacks from the people writing the regulations, which really is the real drive here. And I'm going to get to this in a second. The real drive here is that, hey, if COVID-19 is a grave danger in the workplace, it shouldn't be based upon the number of employees. It should be for everybody. And then the second question is can OSHA treat workers in and of themselves as a hazard in the workplace? In other words, it's not COVID-19 that is the hazard in the workplace, the grave danger. It's COVID-19 within a worker that presents themselves at a workplace. And so for the very first time, OSHA is taking the position that the presence of a worker may in fact constitute a grave danger. It's entirely new territory, and the legal basis to support an ETS on that is somewhat questionable. Can we go to the next slide, please? Here are some expected legal challenges, and I'm going to talk about balances here in a minute. In Texas, and there's a reason why I'm going to focus on Texas here in a second. On October 11th, the governor signed an executive order requiring employers to give broad exemptions to vaccine mandates. The Texas governor feels that he still has executive authority under the pandemic rules to issue executive orders, but in the event that he doesn't, he's also called the legislature back into session, and House Bill 155, which is pending, would provide a specific exemption for an employer for reasons of conscience. In other words, as this mandate is being rolled out in Texas, at least, there's this idea that an employee could say, hey, I don't want a mandatory vaccine because it's a matter of conscience. If that's the case, then those are the people that are going to be subject to this testing out, or what we're referring to as a test out option. Florida, the governor has requested the legislature to enact a law barring employers from firing workers over any vaccination requirements. So as an example, if an employee said, I don't want to be vaccinated, plus I'm not going to tell you, in Florida, what is being proposed is a law that would prevent the employer from taking action against them. So the employer would be put in that squeeze spot. And as of last night, Governor DeSantis, the Florida governor, is calling the legislature back into a special session to enact this type of law. And one of the interesting parts of that law is that an employer would be liable for any adverse reaction to an employee that is caused by a forced inoculation. Totally brand new ground. We do expect to see challenges from Arkansas, from Florida, from Ohio, and from Texas. And I think your strongest challenges are going to be from Texas. In particular, the Seventh Circuit seems to be inclined to hear these types of cases. So I do think that you're going to see relatively quickly a legal challenge from Texas. We've actually already seen a lawsuit filed against OSHA taking action for an ETS. It's currently on hold, but I do expect at least Florida and Texas to be well in the fray. There was also a letter signed by 24 attorney generals to OSHA as part of this comment period, indicating that they would not want this mandate and are very concerned about both the mandate and the time to implement any vaccine mandates. Next slide, please. So here's the issue, and I think this is kind of a common sense approach here. The issue for employers, for when, not if, legal challenges are going to be filed. And I think it's really important for us to get on the same page as to it, because legal challenges are going to be filed. And as a result of those legal challenges, if an injunction is not issued right away saying that this law is put on hold until the courts sort it out, what's an employer to do? We start off with the premise that the White House goal here is to reduce the number of unvaccinated Americans. It's one of those unstated goals, but but all I can tell you is that it's pretty clear that the OSHA rule, the ETS, is really a device designed to forward the White House goal. We can talk about whether the goal is necessary. We can talk about whether or not the rule itself will promote that goal. But in the meantime, if the big picture is that you have to understand that this is probably less about a hazard being present on the workplace and more along the lines of reducing the number of Americans that are currently unvaccinated. So irrespective of an ETS, employers still have a duty under the general duty clause to make sure that their workplace is reasonably safe. And what we have seen in the pandemic, where OSHA has taken action against employers based upon failure to mitigate or remediate COVID exposures in the workplace, they have gone under the general duty clause. That general duty clause applies to all employers with one or more employees. So one of the things to think about, and an employer has to consider as part of this, what do I do now, is that OSHA may be litigating over the ETS, but if you have a COVID issue within the workplace, you are still going to have an obligation under the general duty clause to mitigate exposure within the workplace. Second, one of the big questions is, under this general duty clause, does this allowing employees to test out of the mandate actually protect the employees from this grave threat? Again, I don't think an employer or any legal challenge is going to be successful claiming that COVID-19 is not a grave danger. I just don't. Everything that I have read, I think everything Leah has read, indicates that the courts are not going to second guess that. So then the question is does this ETS and its ability to allow people to test out, does it actually protect the workplace under the general duty clause? So as an example, having somebody test on Monday, but not getting test results until Thursday, or getting verified test results on Thursday, does that really protect the workforce if that person is exposed and a carrier of the virus? And so employers are, if you look at that first point there, which is the whole goal here is to get everybody vaccinated, you can see that this exception for testing out under OSHA is going to be very problematic. Then here's the dilemma that employers are going to have. Absent an issued injunction, do you as an employer, one, run the risk of being exposed if the ETS is upheld? In other words, say you're an employer in Texas. We have a number of employers on this call, on this video from Texas. So say you're in Texas, and Texas files a lawsuit, requests an injunction against the ETS, claiming that it's not valid. Do you say, okay, I'm just going to wait and see how the lawsuit runs out and run the risk of having exposure of $14,000 per violation if that ETS is upheld? That's a pretty substantial exposure. Second, if you're not going to do that, are you going to incur the substantial cost of compliance, which may be unnecessary if the ETS is thrown out? And that would include the cost of tests, the cost of monitoring your workforce as it relates to those tests, the cost of implementing a record keeping system and monitoring those records. And so that's kind of a Hobson's choice. Neither side is really good. So the third possibility is that an employer simply do what some of the large employers have already done, to say, look, I'm not going to get in the middle of this. I'm just going to mandate that all of my workers be vaccinated. And that way, I'm not going to worry about the test out. I'm not going to worry about those related costs. And I could be suspicious and I could be wrong, but if the goal here is to reduce the number of unvaccinated Americans, some of this confusion and chaos that is present may in fact be designed to get employers to say, look, I'm just going to mandate my employees get vaccinated. So there are three options that an employer has here. One, run the risk. Two, comply and incur the cost of complying. And maybe that's just wasted money. Or the third thing is simply say, look, I've had enough of all of this. I'm just going to mandate vaccines. Could I have the next slide, please? So here are some of the things that you need to consider, any employer needs to consider. One is you need to pay attention to, within your county, the current community transmission rate. And these are rates that are published every single week. The last set of rates were published 2 days ago. And right now, 82% of all counties within the United States are rated as high transmissions. That's down 6% from the week before. My gut tells me that it's probably going to be down the next two as well. But then as the weather changes, things get colder, especially in the south and in the east, particularly the northeast, and people start spending more time inside, you're probably going to see that trend go back up. Substantial, which is the next level down, is 11% of all counties. So 93% of all counties in the United States are either high or substantial. And what does that mean? It means that a court is going to be put under tremendous pressure to rule against any ETS based upon what the existing political and medical evidence is. And Leah already touched on it, and I'm going to touch on it again. What we have seen is, outside of the religious accommodation and religious exercise areas, the courts have generally refused to second guess legitimate public health decisions in this area. And so I think you need to put that into the decision process. And at the same time, OSHA's track record on ETS, emergency orders, is really poor. I mean, they're 1 for 6. Including very significant chemicals that were in the workplace, where they decided to bypass the normal process and say, look, the workers are being exposed to these carcinogens and we need to do something immediately. OSHA's track record here is really poor in defending them. And a lot of commentators, myself included, feel that the courts do not like this rush to judgment sort of approach. And that may be, by the way, that may be one of the reasons why OSHA, or I'm sorry, the White House has had so many, they had 50, I think 51 or 59 this last week, short briefings with different labor unions, different business groups, where they basically just sat mum and heard what people had to say, so that they can argue in the legal process that, hey, this wasn't really a rush to judgment. We heard what everybody said, we listened to what they had to say, and then we passed the rule. The other thing is that everybody needs to understand that OSHA has limited compliance ability. In other words, their enforcement ability is limited. They have limited compliance officers, and they have limited administrative support. So I would not expect to see OSHA just going broad on this whole thing and going after every employer. I would think that OSHA is going to kind of focus in. And so if you can give me the next slide, please. So here's the issue if you decide to comply and then wait and see what happens. OSHA has a special rule regarding medical records. I think everybody understands that for most employment records, you need to keep them for 3 years past the time you terminate somebody in most states. Under OSHA, if you are going to be collecting information about vaccination, testing, and things like that, OSHA has a 30-year medical record retention rule. So you're going to have to make sure in your, we're going to comply and wait and see what happens, that you are now identifying those records so that they are retained for that 30-year, not a 3-year period. You are going to have to incur all costs associated with the vaccination or testing out. My my read of the tea leaves, and we're going to have a tea leaf reading here in a few minutes, is that under the emergency rule, all those costs are going to be put on the employer anyway. But right now, if anybody was going to say, okay, we're going to move forward and we're going to comply and wait and see what happens with the litigation, you're just going to have to understand that the cost of testing, the cost of for non-exempt employees, the hourly rate for them to go get tested, come back from getting tested, the time they spend at the testing facility or the time they spend testing on their own, that's all compensatable, as well as the cost of any testing equipment. And I would tell you that I'm anticipating that the emergency order will be accompanied by additional mitigation requirements under the general duty clause, which would include masking, consistent with the CDC requirements, ventilation or enhanced ventilation, including HEPA filters in shared workspace areas, and some form of social distancing. The labor unions, particularly the AFL-CIO, in their presentations to both the White House and the Labor Department, raised all three of these as key additional issues. In other words, vaccination is great. Testing out of vaccination is not great. We don't like that. But vaccination, testing, and additional mitigation is what we're really looking for. And then I think if the decision is we're not going to do anything, we're just going to wait and see. I just have to remind you that the violation for not having a test for a non-vaccinated individual is $14,000 per week. And so that's a significant amount. Next slide, please. All right, so I think this is back to Leah now.
Thanks, Bill. So I know we've talked a lot about different things that employers have to consider. And one of the things that we can do while we're waiting for the final rule to be released are some of the things that you as an employer can do in order to prepare. So in our last presentation, we talked about potentially doing surveys and other things in order to understand what your workforce composition might look like and some of the things that might work best for you as an employer. And so some of the issues that have come up that I think a lot of employers are most interested in are how will you be counting employees and how will that 100 or more employee threshold be determined? And ultimately that will be issued in that rule, in that final rule for the ETS. But some of the things that we know is that it will include all part-time employees, all full-time employees, and seasonal and temporary employees. And that's just kind of based on the definition of what OSHA considers to be an employee. The count is going to likely include remote employees, and that's based upon the information that we have from existing ETS and from the executive orders. OSHA uses a common control or a single enterprise counting method. So this means that it doesn't look at the location. So if you have multiple plants across the country, you're going to look at all of those plants together. If you have different subsidiaries, if they all use one management system and one common manager or one owner, then likely all of those employees from those different subsidiaries are going to end up being one company and you're going to add those all up to see if you reach that 100 employee threshold. One of the interesting things that OSHA has previously decided on is the relationship between employment agencies and on-site employers. So if you hire employees from an employment agency, both of you are responsible for that workplace safety. Now, the employment agency doesn't have to come on site necessarily, but if they become aware that there are workplace hazards, so for instance, if employees come back to the employment agency and say, the employer doesn't have any type of COVID protocols, or similarly, if the employee goes to the employer on site and says, I have concerns about this, both of them will be duly responsible for that. So likely here, you'll be counting both ways, and both of those entities will be responsible for ensuring that either employees are fully vaccinated or that they are going through the at least weekly testing. So we've been talking about the idea that likely testing will have to occur weekly, but the language that was proposed was at least. So there is the possibility that it could be more often. And as Phil said, that's a $14,000 per violation. Our previous calculations were based on a weekly method, but if the final rule comes out and says that you have to test twice a week, then that could potentially be a $14,000 violation for each test that's missed each week. So it could be a significant amount of money, even for just a handful of employees. By comparison, in Texas, violations of the prohibition on treating individuals who object to being vaccinated based upon certain exemptions, that fine is capped at $1,000. So there are different, economic factors at play whenever an employer is kind of looking at which landscapes they fit in and what they need to provide and what they need to comply with. Contractors, both independent contractors and whenever you have a general contractor and a sub, whether that's a construction site or an oil field, those have been some things that have come up. Generally, OSHA does not consider independent contractors to be a part of the workforce. However, whenever we are looking at the executive orders, who is working at the work site has been a very important part of who has to be vaccinated or who has to comply with the mitigation requirements. And so that's something that we'll be looking for in that final ETS rule for clarification. Some of the other ways that we can prepare are in the next slide, please. And one of the things that we've been asked quite frequently about is what will we be required to do in record keeping and in order to comply? So again, that key word was ensure that people be fully vaccinated. And what does that mean? A lot of employers have throughout the pandemic kind of adopted this honor system where it's, if you're fully vaccinated, you have to comply with these measures. And if you're not fully vaccinated, then you have to comply with these measures. But the employer hasn't asked for proof. They've just relied upon the employee's honesty. Moving forward with the ETS rule, that's likely not going to be sufficient. If the standard is that you have to ensure compliance, then you'll need to take actual steps in order to provide proof. It would just be like, with I-9, you can't just, ask employees if they have a passport or if they have proof of citizenship and take their word for it. You actually have to, see the document. And here, if you're required to have insurance of it, you're likely going to have to either get a copy of it or want to have that copy for your records. So employers should start to prepare and think about what type of record keeping system they're going to need to accommodate 100 or more employees, whether that be record keeping for a one-time look and copy of full vaccination records, or weekly or at least weekly testing. Some of the things for record keeping that will be big considerations, obviously, will be privacy, which we'll discuss here in a moment, but also whether or not home tests will be acceptable. And if they are, how will you collect the records and how will you ensure that those home tests are accurate? And then for remote employees, how will you, obtain that information from the employees who are not reporting to your work site? And as Phil said, for OSHA, those medical records have to be retained for 30 years. So whenever we're looking at the systems that are going to be put into place, understanding the cost and also the ability of that system in order to maintain those records for that long will be very important. One of the other things that we need to consider whenever engaging in record keeping is employee privacy, because we are talking about potential medical testing and medical information. So proof of vaccination generally is not considered to be a medical test. And that is why in most jurisdictions, with a couple of the states that we discussed today and a few more as exceptions, proof of vaccination currently can be required, meaning that an employer can mandate that its employees provide proof of vaccination. And that's true with or without this ETS. So whether you're a large employer or a small employer, you currently can require your employees to show proof of vaccination. But that will be personal, private information, and it has to be kept confidential and provided only on a need-to-know basis to those individuals who would have cause to know that. So for instance, if you required separate mitigation for individuals who are not vaccinated and you needed to tell supervisors, who needed to comply with that, you could provide that information, but you wouldn't necessarily be able to tell, a customer who was and was not vaccinated. And that's why that information needs to be kept confidential and separate. And those are the considerations that you'll want to have in setting up your system. Testing, however, is generally considered to be a medical test. And so it's medical information. And there are certain things that go along with that of an increased nature for privacy concerns. The same with confidential information, it has to be kept separate from your other employment records. And so you'll want to take that into consideration whenever you're weighing out the different options for record keeping. I see a lot of questions in the chat box, and hopefully we've answered some of them. And Phil's going to give us a little tea leaf reading here and hopefully answer some more, and then we'll have some time to answer the rest.
Great. So what do the tea leaves predict? I would expect the rule to be published next week. The rule has been at the White House for 2 weeks. I mean, maybe this is an inappropriate comment, but for something that was an emergency and that was announced September 9th, here it is, October 22nd, and we still don't have anything. So I would expect the rule to be published next week. I would anticipate the effective date of the rule to be in December. Again, this is a wag on my part, but I would expect somewhere around December 8th. I know that the retail industry, retail employers in particular, have requested that the implementation of the rule be put off until after the holiday season because of, just everything that's involved with pre-holiday and post-holiday sales. But I don't expect that to be occurred. Since OSHA doesn't have full administrative capacity to enforce the ETS, I think that employers are the goal here is to deputize all you employers to be OSHA compliance officers and to make sure that everything's being done. So you can raise your right hand and be admitted to OSHA's Voluntary Enforcement Bureau. You already know that if you have a government contract over $250,000 or as otherwise directed by individual agencies, you have a mandate that must be complied with. I think the large employers, the very large employers, they've already started to mandate vaccines. So those are the ones that normally have the money to extensively litigate these items as opposed to state. So I'm not anticipating seeing Amazon make a filing as an example. So what I would expect to see, quite honestly, is that OSHA will target their enforcement. They will find a smaller employer, say somebody that has around 250 to 300 employees, and they will make an example of that employee to encourage everyone else to be compliant with the rule if that rule is upheld. The cost, my gut tells me the cost is going to be 100% on the employer. The honor system is not going to be permitted. There's going to be record keeping requirements. You're going to have to see, touch results, not the actual results, but the reports. And that remote site workers will not be exempt. In other words, you have somebody that works 100% remote, no matter what. They never come in contact with anyone else. I would expect those remote site workers to be included in the rule. I did see one question pop up here, and this would be a tea leaf thing again. And the question was, what happens if I've got total in all the company, I got 100 employees, but I got 30 here, I got 70 there, I got 10 here. Under OSHA, because OSHA is a federal agency, all of those workers are aggregated in your total employee count. You're not going to be permitted to say, I only got 20 employees in the state, therefore I'm exempt. It's going to be a total aggregation. And as Leah said before, part-time, temporary, seasonal, full-time, independent contractors, and what we call PEO or employees you get from temporary agencies. You need to count those as well. That's my gut. I know we have a whole lot of questions, so maybe you can go back on screen, and Jenna, maybe you can, or Mala, you can just start giving us some questions, and we'll give you our best reasoned guess right now.
Yes, so we are going to start our question period now. We will probably go a few minutes over time. I know everybody's eager to get those questions answered. So I'm going to turn it over to Jenna for the first question. Thank you.
Yes, because we did get a few submitted through email as well. So I'll start with one of those. One person says that they're estimating that only 25% of their employees are vaccinated. They are not currently mandating vaccines, but they are doing temperature checks and COVID testing. But the problem is that they're having difficulty finding availability of COVID tests. And they keep checking for availability and they're not having a good time finding them. So if the mandate goes through, would doing temperature checks daily and in-house COVID tests every other week help prevent them from being fined?
It depends on the rule, but my gut tells me no. And I do indicate, I agree. The White House has already acknowledged that availability of in-home tests is limited. They've invested $1 billion to acquire and purchase in-home tests. The president has not initiated action under the Defense Appropriation Act to basically privatize industries that would be able to produce those results. And that whole issue of home testing, it'll be interesting to see what's out. But I do not expect the ETS to permit temperature tests, self-certification. I'm not sick. None of that. I don't think any of that's going to work.
Okay. I'll grab another one. We had one and it's in the chat. So they have they're in a manufacturing industry and they're unionized. And so they have 40% of their workforce is advising they refuse to get the vaccine. But if they lose 40% of their workforce, how are they going to be open for business? And then the union is also against the mandate as well. Do you have any suggestions for how to handle that?
My thought is that you probably need to enter into the meet and confer process with your collective bargaining group right now, and start working through the process. It is not going to be a defense that the labor union is not allowing us to mandate vaccine or test. That's a big fight. I was talking, if you're following the press, that's a big fight going on in Chicago right now. It's a big fight going on in New York right now with public employee unions. If you're in the private sector, my thought is that you enter into the meet and confer process right now. I do not expect OSHA or the White House to give any consideration there. I just don't. So it's hard. Leah, do you feel differently?
No, I don't feel differently at all on the meet and confer. I was going to say on the subject of losing the workforce, we've had this come up a lot with employees saying, if this happens, I'm going to leave. And we haven't seen it come to fruition as much as it's been threatened. But one of the things that we have seen is a loss of workforce whenever there is a COVID exposure in the workplace, and unvaccinated persons have to quarantine, and only the vaccinated persons are left to work. And so that's one of the things that employers should also take into consideration if they have a largely unvaccinated population, and they're engaging in the testing. Even if the person tests negative, if they've been exposed, they'll still have to go through that quarantine procedure. So vaccinated individuals would be the only ones who wouldn't have to quarantine. So obviously, it's a delicate balance whenever you have workers who are saying that they will leave if there's a mandate. But sometimes you're also forced to have a reduction in your workforce because of quarantine procedures. And so that's something for employers to consider as well.
And this is one of those technical issues, and I don't want to go too deep in it, but there's a difference between an employer complying with the law. That is not a subject of mandatory bargaining with the effects of you complying with the law. And so as an example, if the employer makes a decision that whatever this ETS is, we're going to comply with it, that you don't have to bargain that with the union. But how you implement that process is something you do have to bargain. Next question.
So this question is in regards to complying with what the fee would be if you don't comply. So hypothetically, if someone has 100 unvaccinated employees and none of them have been tested for 1 week, will the fine for this be 1.4 million?
Assuming that you also have no information as to whether or not they're vaccinated, then the answer is yes. It's 100 times 14,000. It's a fine that exceeds somebody falling off the roof of a building due to the negligence of the employer. It is an incredible economic burden.
And then I did see, and I believe you've addressed this, but we're assuming that the majority of the cost will go on to the employer for that.
I'm saying 100%, not the majority.
Oh.
100%. There is no way that this administration is going to require an employee to come up with a dime.
It's already required.
Or lose any time from work. You know?
Yeah. It's already required under the FLSA that you would provide the employee with pay for the time that they experience for testing, because it's something that's required by employment. And the administration has already said that the time off to become vaccinated will be one of the things that will be required under the ETS. So the thing, and right now the cost of vaccination itself is free. So really the testing itself, the cost of the test is what is outstanding. In some states, that cost is already required under their wage and hour laws that it be provided. So that's the only thing that we're kind of waiting for the ETS, and I agree with Phil. I don't think that there's any way that the rule will say that the employee has to pay for the cost of testing. The other thing is if you're using that as an accommodation for someone testing, the ADA and the EEOC would provide that you as the employer have to pay for the cost of that accommodation.
Yeah, and then the other thing would be is even if an employee is vaccinated, so say they go in for their booster and they have an adverse reaction, and there are significant adverse reactions that can come about with the booster shot, even if you had no reaction to the first and second shots, that time is compensatable PTO.
So we have about 5 minutes left for questions. Obviously keep sending them our way, and we're happy to reach out to everyone after the webinar and make sure you get the answer. But just to address a couple more that we've received. Someone asked, we've not had a transmission of COVID at the workplace for months. All cases have been determined to be exposures to others outside of work. How can OSHA mandate testing or vaccination to an industry where there is very limited transmission potential?
How can OSHA mandate testing or vaccination to an industry where there is no transmission potential in the workplace, such as a workforce that is totally remote, that has no contact with one another? And the answer is that's going to be one of those significant legal challenges, because the argument is that the president is exceeding his constitutional authority to impose this. And that what is really going on is, remember what I told you that goal was? That the ETS is being used in an improper way. And when you look at how it's being used, it exceeds the constitutional authority of the executive branch. That's a very strong constitutional argument. At the same time, the rule's going to be there. And so we need to deal with what are you going to do with that rule, even if you've had absolutely no COVID exposure and you can document no COVID exposure in your workplace. If you have 100 or more employees, that's the magic is 100 employees. The magic is not COVID, probability of COVID, inability to work with social distancing, you know, like meat processing or animal processing plants. This is very, very, very unique. I just saw a question here on the home test. I think, does it have to be witnessed? I don't know. I really don't know. It's going to be interesting to see how that is handled. In other words, the question is, would a home test have to be witnessed? So how do we know that the home test result you are providing is in fact Phil Toomey, you know? That Phil Toomey is just not using somebody else. And we're just going to have to see how that is put in the rule. My gut tells me it won't be addressed. My gut tells me that it'll be said you have to test, and then there won't be a lot of specificity as to how that, if home tests are allowed, how that home test is verified. Any more questions?
Yes, we did get one. If you are testing, does the employee remain out of work until test results are provided?
Leah, I'm going to let you answer that one.
So they should be. I mean, that's, per CDC recommendations and just basic common sense is if you're going to get tested for something and if you test positive for it, then you would need to isolate. You shouldn't be in there. However, that's not what has been prescribed in the testing rules. I think likely what would need to happen is you would have to set up some sort of system where it's okay, you test on this date in advance of coming to work the next week. But the problem again with testing is only a snapshot in time. So like Phil had talked about before, you can test on Monday, you may not get your results until Thursday. But if on Tuesday you went to dinner with someone who has COVID, those tests that you took on Monday doesn't really do anything for you because you had the exposure on Tuesday. So I don't think that if they offer testing as the alternative, that it will be, you can't come to work for several days out of each week while you're waiting for your testing results. It'll probably be something where you have to have the testing as of a certain date from each week before you're allowed to come to work. And so it'll have to be in advance of that work week. But really, as an employer, you shouldn't want those people in your workplace until they have that negative test result, because otherwise, if they get a positive result, you're going to have to take some action. And the people who have been in close contact with them are going to have to quarantine every time you get a positive result, whether that's a false positive or not.
Yeah, I think that the maybe the question is more along the lines. This is like a random test, so it's just being implemented. Person has no symptoms, and so we're just testing them. And I think I don't know what the rule is going to say here. I think the rule is going to say that you probably need to do something after there's a positive test. I don't think it's going to require that because you're complying by doing the random test. That you have to take them out of the workplace. I think that is even too far. There's a question here on the employee count. On the 100 employee count, is it over the previous calendar year, current year, or past year? I don't know. I think the 100 employees or more is going to be a current count. That's my gut. What do you think, Leah?
Yeah, I think it'll probably be for the past 52 weeks as an aggregate, and maybe they'll use like over the 20 weeks, something like that. I don't think it'll be a snapshot date that you get to pick, but I think it'll probably be over some sort of past year. And I saw something in the chat about what about people who are vaccinated and getting COVID? And people who are vaccinated can get COVID. However, all of the studies have showed that there's, reductions in those transmission rates, and that the people who are vaccinated, if they don't have symptoms and they haven't tested positive, they don't have to engage in the quarantine. So that was the clarification from before. So it's not that if they test positive that they don't have to quarantine. It's individuals who are fully vaccinated. If they don't have any symptoms, they don't have to quarantine, whereas unvaccinated individuals who have been exposed, who have had close contact, even if they don't have symptoms, they have to quarantine under the CDC guidelines, which have been adopted by OSHA as the recommendations. So that's one of the things that'll have to be considered. If you're testing individuals who have not been vaccinated and they test positive, they have to isolate because now they're a case. And if they've been around others who are unvaccinated in your workforce, those individuals, regardless of whether they test positive or have symptoms, they're going to have to quarantine. And so it could really explode from there.
Yeah, I think under the emergency rule, don't expect there to be anything about vaccinated people. If you're vaccinated, you're vaccinated.
Yeah.
Under the general duty clause, which is what we talked about earlier, even a vaccinated person that tells you, as an example, that they tested positive or displays symptoms consistent with having the COVID-19 virus, under the general duties clause, you're going to have to follow the CDC guidance. So under the emergency rule, I think we don't have to test vaccinated. All we need to do is verify that they are vaccinated. Once that's done, that's done. And that's one of those touchy areas. And I think everyone's going to have to anticipate that fully vaccinated employees are going to test positive for COVID. I think that the epidemiological evidence is sufficient to establish that while the vaccine is effective on reducing and in many cases preventing, it doesn't prevent someone from carrying the disease. And also people that are fully vaccinated can in fact get COVID. Especially people that have compromised immune systems and other issues going on. So I think we're going to have to be dealing with that issue, but that's separate from this emergency rule.
Sure, on a much lower, rate than we see in unvaccinated individuals.
Right.
But, and I agree, it comes underneath the general duty clause. That I don't think that that's going to be covered in the ETS, but I think it's important for employers to consider whenever they're trying to decide what next steps to take, whenever they're considering about that testing process. There will be more than just complying with doing the test. It's not going to be there, I did it. You're going to have to then consider those results in order to comply with the general duty clause.
I did see a couple of questions in the chat regarding the timing of the rule.
Where's our crystal ball, Phil?
Yeah, well, my gut tells me December 8th. Just based on the things I've seen. At the same time, could it be before the Thanksgiving holiday? I think it could, but I just think that that's so totally unreasonable that you're probably looking in that December 8th timeframe, December 2nd through December 8th. If the rule is announced next week. My gut told me the very first time we did this, it would be 45 days after announcement of the rule when you would see that affected. But that's what my gut told me, that on September 9th, that the White House wouldn't be making this broad-based announcement unless internally it had already vetted out the key parts of a rule. So I actually expected to see the rule the very next day or the next week. Now we're, 6 weeks later, 8 weeks later. My anticipation is you're gonna see at least 30 days.
Yeah, I think you have to give at least 30 to 45 days as a runway, because that's how long it would take someone to reasonably get fully vaccinated.
Right. Yeah, I think that's the key issue.
Okay, well, we're actually out of time for today. Thank you, everyone who submitted questions and who attended today. We will contact you directly about any questions that you had submitted that we did not get to answer due to time constraints. The recording and the PowerPoint slides will be made available to all the attendees. If you'd like to connect with Phil or Leah, please don't hesitate to reach out at the phone number or email addresses that you see on the screen. Thank you again for attending and have a great day.
Thank you.
Thanks.